Okay, Fox News alert. This just coming into Fox, as you were just hearing on Happening Now. We are getting the verdicts now in the prep school new case. So far, Molly Line has been on the case for us right there. We're waiting for her to come right back up. But 5 guilty verdicts, it appears, and 4 not guilty verdicts in the prep school rape case. But for the 3 major felony rape offenses, those were 10 to 20 years possibly in prison. The jury found him not guilty. Let's go directly back out to Molly Line, who's in Concord, New Hampshire for us this afternoon. Molly, describe for us again the charges and what he's guilty of and what he's not guilty of.
Gretchen, these were very serious accusations that have been leveled against Owen Labrie, now 19 years old. Prosecutors saying that he was accused of raping a 15-year-old underclassman during his time at the St. Paul School here in Concord, New Hampshire. The charges are broken down into several felonies and then a multitude of misdemeanors as well. Now, he's been not guilty on all of the most serious felonies, the aggravated sexual assault felonies, specifically the aggravated felonious sexual assault. Those were the charges that carried the 10 to 20 years possibility in prison. So he got not guilty on those. But the other charges that are related to misdemeanor charges, also involving sexual contact with this younger individual, with the victim in this case, he was in fact convicted on those charges. He was guilty of those charges. So what we have here is a not guilty for the aggravated felonious sexual assault, but a guilty as far as also using a computer to solicit, to induce, as far as the contact is concerned, to begin the relationship, in other words. And then a not guilty on the simple assault charge, but a guilty on the endangering of a welfare of a child, and guilty on 3 different counts of sexual assault. Now, these were also the misdemeanor counts here in New Hampshire that he was charged with as well. Gretchen?
Okay, so I'm just trying to figure out now that by my count, that's 5 guilty charges then, and let's see, 4 not guilty. It's interesting that he's found guilty on certain uses of a computer, and then those other 3 sexual assault charges, Molly, you say they're misdemeanors. Do you know anything more about them?
Yeah, so the reason that these are misdemeanor charges it has to do with consent. Those first 3 aggravated felonious sexual assault counts were about consent, that the victim did not freely consent. Those were the charges that he was not guilty on. These charges, the misdemeanor charges, are essentially based on the fact that the victim in this case was under 16 years old, so that's the age of consent here in New Hampshire. She was 15, but there was less than a 4-year difference in the ages between the two, between the victim and between the now convicted Mr. Labrie, and so he's still breaking the law here in New Hampshire. That is still a misdemeanor to have that contact with the juvenile female. And there are several different sex acts. That's why there are the several different convictions related to the specific sexual assault. So there's a specific sex act with each of those guilty verdicts that he's been convicted of.
Okay, Molly, thank you so much. As we're looking at a live picture now inside the courtroom, that is the defendant right there, Owen Labrie, as he's finding out that he's guilty on 4 charges, guilty on 5, not guilty on 4. May have that reversed, but whatever the case is, let's bring in our legal panel, Tom Caniff and David Bruno, both criminal defense attorneys and former prosecutors. All right, so it appears, Tom, that the most egregious charges here, the most serious, 10 to 20 years in prison, he's technically not convicted of rape, right?
He is not convicted of rape. These acquittals are about consent. The jury clearly found that the prosecutor did not prove that this was not a consensual encounter. But at least when we're dealing with respect to the misdemeanor charges, the law in New Hampshire prohibits sexual contact between with anyone who's under 16. Okay, obviously the complainant in this case was 15. The defendant was 18. Now a lot of people would look at that and say, look, 2 people going to the same prep school, they're both in high school. This is not really what this law was intended to prevent.
Right.
But a plain reading of the statute makes that conduct illegal. I think that's why his lawyers from the beginning were trying to say that no sex had occurred, because that was the only way to get around these charges.
In fact, she herself said that she wasn't sure to a friend whether or not the actual sexual intercourse had occurred. David, are you surprised by this? Because the prosecutor had to prove beyond a reasonable doubt that was tough in a he said, she said with no physical evidence.
Not surprised at all, but if we look at these charges, what's clear is this jury found that there was penetration. In fact, on the 3 sexual assault misdemeanor charges that he's been convicted of, it required the state to prove penetration, penis penetration, number 1, digital penetration with a finger, number 2, and oral sex. So those are the facts that were required for this jury to find those 3 charges, and they found him guilty. Therefore, this jury was convinced beyond a reasonable doubt that those sexual encounters actually happened.
But they don't believe, so consent is what it boils down to, is what you're saying as far as the more serious charges, because those are misdemeanors.
Right. That was actually, it's actually clear also in the simple assault charge, because that simple assault charge required the unprivileged physical contact.
But he was not guilty on that one.
Not guilty of the simple assault.
Okay, guilty
so
of...
It's the consent issue that the jury found him not guilty on the aggravated sexual assault, the major felonies, as well as the simple assault, which required an unprivileged contact.
Okay, I want to go back to what you were saying earlier, Tom,
Right.
because all the parents at home right now watching, or grandparents, myself included, if you're going to have teens, I mean, 18 and 15 years old, as you say, they're at the same school. Who knew that it was a Class B felony to get on your computer and say, hey, do you want to hook up tonight?
Right, and that's, you know, Gretchen, you brought it up. I mean, that's the toughest part about it. I mean, that felony charge is serious business, because he's going to be looking at, in all likelihood, a state prison sentence as a result of that.
Wow.
And
So,
again, you know, this is a law that was intended, you know, for older guys who are trolling, you know, basically pedophiles operating out of their basements. It wasn't intended for kids going to the same prep school. So, you know, this is a real tough pill for him to swallow.
Okay, so when the jury is trying to hash all this out, they obviously unanimously agree that they couldn't go to the consent part,
Correct.
right? Do they have an understanding that computer services?
No.
Do they have an understanding that's a Class B felony?
They don't, because a jury is not supposed to consider punishment. They're supposed to reach their verdict on the facts. In fact, the judge would have told them several times before they even deliberated that that is not within the purview of the jury. The jury decides the facts, the judge imposes sentence. So they may have no idea what they did in this case.
Wow. So this Class B felony, 3.5 to 7 years?
Yeah, it carries a potential range of 3.5 to 7 years. But that's going to be within the discretion of the judge. As far as I see, there are no mandatory sentences here. And certainly for this defendant, there could be a phenomenal mitigation package and a mitigation argument to the judge when it comes to sentencing.
What do you mean by that?
Well, this is a first-time offender. He's 18 years old. Other than this act, he's probably led a law-abiding life. He was accepted into Harvard. He was in an excellent high school. You know, so all these things are going to be taken into consideration.
These are registrable offenses.
Yeah,
I mean, this is going to be mandatory
but
Megan's Law
let's just
sort
think
of
about this.
registration.
How many 18-year-old boys in the United States of America today have had some sort of a sexual encounter, possibly with a 15 or 16-year-old girl, in a consensual relationship because they deemed it now to be consensual, and they go to prison for 7 years?
It's a very tough situation. There's going to be a motion here to this judge to try and get the judge to set aside the verdict on this count. The defense is going to try to formulate some sort of interest of justice argument. It's going to be a very, very high burden, and it probably won't happen. You're going to have appeals that maybe will test the constitutionality of the statute, but it's a very tough case. I mean, the fact that the jury determined that this was consensual, yet this defendant walks away with this degree of, I mean, a registered sex offender. This guy's life's over right now.
I was just going to say, I didn't want to go to that extreme, but here you have a kid who potentially has never committed another crime, who's going to one of the top prep schools in the nation, was accepted to Harvard in the divinity program, no less, and now, according to this jury, he's not guilty of rape. But he, in fact, may go to prison and, as you just said, Tom, have his life ruined.
Yeah, the registration's not going to actually kick in here. In this particular, actually, he benefits a bit here for the statute because the statutory rape laws throughout the country don't necessarily always distinguish between the 18-year-old and the 15-year-old.
I was just going to ask you that. So each state is different?
Sure, it's a state law. So here, because it was 18 and 15, he got the benefit of this being a misdemeanor statutory rape as opposed to a felony. If he were 19, it would have been a felony conviction.
So is that what Molly Line was talking about earlier, that because their age difference was less than 4 years?
Correct. That's why it's a misdemeanor. It's a Class A misdemeanor as opposed to the general felony statutory rape charges that we see throughout the
For instance, in New
country.
York, for statutory rape, you need a complainant or victim who's under 17 and a defendant who's 21 or over.
So again, for any parent out there watching right now, if they have a 15-year-old daughter who's dating an 18-year-old guy, and they're having some sort of sexual encounters, they can charge them with the crime?
Yes. Yes, and it's eye-opening. I mean, this is certainly eye-opening. It's devastating. I mean, it'd be one thing, look, if he just walked away with misdemeanor convictions. I don't want to minimize that, because the reality is a sexual assault misdemeanor on your record can have a devastating impact as well. But the fact that he's going to be a convicted felon and looking at up to 7 years in state prison and all the other collateral consequences of this conviction, it's a miscarriage of justice.
But will the sentencing be all up to the judge in this case, Dave?
Yes, it will be. It'll rest in the discretion of the judge, and he will have the ability to sentence him lesser than the 3.5 to 7. Okay, so there are ranges, but like I said, the arguments are in mitigation of this defendant and could be less than that.
Okay, and I don't want to take away from the seriousness of what may have happened to this girl as well, because once again, it was a he said, she said situation. The jury ended up deciding that it was consensual, but they also ended up deciding that he was guilty of these misdemeanor sexual assaults, right?
Correct.
Now, is there a consent element to those?
No.
There is not. It's a strict liability offense. I would call a per se offense. So the idea is that, look, she could have been ready, willing, and able, and it looks like the jury found that she probably was. She could have been the one that prompted the encounter. But because of the age disparity between them, it's a per se crime.
So this all comes down to the age in your minds?
With
Yes,
respect to the
that's
misdemeanor offenses, absolutely.
And the Class B felony with regard to the computer?
That comes down to the age, too, in the sense that it's a crime that prohibits the use of computers to lure a minor into a sexual encounter, which was done here, but it doesn't mean that it was done without her consent. Mm-hmm. She can't consent to it because the law says she can't, because she's under 16.
All right. So when a prosecutor gets a case like this, you are compelled to press charges?
Well, this is the dilemma for prosecutors, because these are very difficult cases to handle. There is a large amount of discretion that prosecutors have to bring charges and how to resolve them by way of plea offers. A prosecutor has the ability to use diversion programs even on these types of charges, but generally that happens before trial. This defendant had a constitutional right to go to trial, and I think he went to trial because of the aggravated sexual assault counts. And I don't know what the plea offers were extended to him, but he had to make a decision.
Could it also be, 30 seconds, Tom, that we've had a lot of talk about sexual assaults on campuses? I mean, does that play at all?
Absolutely. I mean, this is a tragedy, and you hear everything about rape epidemic and so forth. And look, sexual assaults and rapes happen, and when they occur and when the evidence is there, they should be prosecuted vigorously. However, there is also an epidemic, I can tell you as a criminal defense attorney, of people making false allegations of rape, and there's tremendous pressure on the prosecutors to bring this case, and frankly, given the inconsistencies in the victim's story here, I don't think this case should have ever went to trial. I don't think he should have ever been charged.
Wow.
This should have been dealt with in some other way, and now a life is ruined. I mean, there's no question.
He's a convicted felon now, although he's not convicted of the most serious charges. Lawyers, thank you much.